Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. It's Thursday night, and we're here like I am each and every week to talk about all things debt related. If this is your first time here to our weekly live stream, this is what we do to answer questions. I started the Consumer Warrior YouTube channel years ago with the whole purpose of providing information and in-depth information for people on who are dealing with really serious debt problems. And so the whole goal of the weekly live stream is to really kind of dive deeper into that. For those of you who don't know me, I'm an attorney in the state of Arizona. I do mostly bankruptcy work, and then I do a lot of what I call debt defense, defending people who are getting sued by junk debt buyers like Portfolio Recovery Associates, LVNB funding. We're seeing a lot of LVNB stuff going on lately. Unifund, Encore Capital, all those guys. So if you do have a question, go ahead and put it in the chat section. If you're on YouTube or if you're on Facebook, go ahead and put it there. I'll put it up on the screen. My little word of warning, this isn't legal advice. This is just some guy talking on YouTube or on Facebook, so take that for what it's worth. Really quick, before we get into some of the questions, I see we've already got questions there. I wanted to remind people about some of the people who help bring this to us each and every week. Some of our sponsors of this weekly live stream. One of them is Solo Suit, which I think a lot of you, I get a lot of feedback. A lot of people use Solo Suit to help in drafting the debt, the answer to the debt collection lawsuit, motions to compel arbitration, and even debt settlement. So there's a link in the chat section. If you want to learn more about them, click on that. They have some cool products, and they help us to do this each and every week. And also Ascend Finance. Now, I have put before, and you'll see them down in the notes below, one of the biggest questions I get when people come to my office here in Arizona about filing for bankruptcy is they want to know, do I qualify for Chapter 7, Chapter 13? It's really hard to find reliable information online, but the guys over at Ascend have done a great job of putting together a calculator, which helps run you through that to be able to determine if you do qualify for it. So I think I can put a copy to, see if I can do this in real time. I'll put a link to it. If you're considering a Chapter 7 bankruptcy filing, it's great before you even talk to an attorney to have some idea if you're going to qualify. So they look at things like household size, income, all that, but you can go ahead and click on that. There's no charge to that. They do it free. I actually have a cool little video that I think shows you a little bit how it works. So you can see this. They take you through Chapter 7, Chapter 13. They can show you the differences between the two and just walk you through the whole process. There's a questionnaire you fill out, and it gives you some just general advice on ways to deal with that. So go ahead and check out those people. Great. I know the owners of both of those companies. They do a great job in helping people. So, all right, let's jump into, I saw Daniel was here nice and early, so let's go ahead and jump in and talk to his question first. Daniel said, I was kicked out of my home back in November and doubled my debt to $36,000. The minimum payments are higher than I can afford, and I've been making partial payments on my new accounts, skipping the old ones. Throws in there, he's probably paying like $25 a month on those older accounts. He says, I'm concerned that when I file bankruptcy, it might look like I was trying to game the system. I plan on filing around July. I guess what I'm asking is, do I have the right to be concerned, or am I overthinking it? Thanks for any input. Well, Daniel, thanks for the question. It's a good question. And your question has me thinking of a couple other questions that I would ask. I mean, one of them is, why wait? Why wait until July? There may be legitimate reasons. You don't need to respond to that. But sometimes, Chapter 7 process, Chapter 7 bankruptcy takes about 4 to 5 months total. You could file it, we're recording this in April, and you'd be done by July, August timeframe. So, but as to your question, the fact that you're not able to pay everybody, or you're paying a partial payment on some creditors and not others, that you're not gaming the system. And truthfully, that's most people who are dealing with really serious financial struggles, who are heading towards bankruptcy. There's a lot of, borrowing from Peter to pay Paul kind of thing. And so there's this survival mode where you've got this game where you're trying to cover your basic living expenses, keep your house, keep your car, but also keep the creditors at bay. So I don't see, from what you put there, I don't see that would be anything I would be concerned about. Nothing that I would lose too much sleep over. I'd recommend talking to an attorney in your particular state. If you're in Arizona, my information's below. Something I have been doing is let me put even my calendar link in the comments. If you do want to set up a consultation, I don't charge for them. You can just pick a time, and I just put the link in the comments there. You can click on that and set up an appointment, deal directly with me. All right, let's jump into the next one here, which was Monterey MX. How long before you file Chapter 7 should you sign up for the debt counseling? So this is a good question. So if you file a Chapter 7 bankruptcy, you have to do a credit counseling class before we actually file it. And credit counseling class is giving it a little more substance to what it really is. It's a video you have to watch online. It takes about an hour, not a huge deal. The thing is, so like once the client takes it and I get the certificate that we have to file with the court, it's literally a one-page document that says they did it. They took the class. And so how long should you take it beforehand? The certificate is only good for 6 months. There's not many people that say, hey, I'm going to file bankruptcy 6 months from now and I'm getting ready for it. But you want to be careful, because I have had clients that they run out and take the credit counseling class and then they don't qualify, or there's something where there's some delay and they end up taking the dang thing twice. There are free ones out there. Most of them are pretty minimal, somewhere between $15 and $25. So they're not a gigantic expense, but there's still some expense there, and you just don't want to have to sit through it twice. So I would say go ahead and if you're about to file for bankruptcy, go ahead and take it. If it's something that's going to be a ways off, you might as well wait. It doesn't take a whole lot of time to be able to do it, and then you don't have to worry about that thing expiring and having to take it twice. I always hate that when I have to tell the client, your certificate expired, now we got to do it again. Kind of along those lines, there was a question in the comments that I was looking at. Common question about the impact of bankruptcy on credit score. This comment said, after 10 years, the voluntary Chapter 7 discharge will go away from the credit scores. What is the effect in terms of points on the credit report? How much will it go back up? So it's true with a Chapter 7 bankruptcy, it stays on your credit report for 10 years. Now, where does it show up? If you look at your credit report, if you pulled a copy of your credit report, there's a listing of all your personal information, and then all your creditors are listed. And then there's a public records section. That's where the bankruptcy will, if you file in Arizona, it will say District of Arizona bankruptcy. It'll have the date and some in your case number, that kind of thing, and have the date that it was filed. It'll stay there for 10 years. Now, your creditors, after you go through the bankruptcy process and you obtain the discharge order, which is the order from your judge that eliminates the debts, what'll happen to the creditors who are on your report, they're still there. However, the balance owed will be zeroed out, and in the notation, it'll likely say discharged in bankruptcy. Now, depending on what your credit score is when you file your bankruptcy case, because that's what's first going to hit, you're going to see somewhere between 100 to 150 point hit just immediately. You're going to take an initial hit. It will build back up more quickly than that 10 years. And frankly, most people's credit score fully recovers within about 18 to 24 months. And so like you can get a regular mortgage loan through FHA, VA, assuming everything else is okay. The bankruptcy will not hold you back from getting a mortgage loan with normal interest rates around that 2-year mark. Some lenders are 3. So your credit score is going to recover much more quickly. I talk to people 2 years out and their credit score is over 700. So it's important to know there's a distinction between the bankruptcy being reported on your credit report and then an impacting score. Most people's scores that I see, and I don't see all my clients, but from those who report back, we're looking at about 650 plus around 18 to 24 months, with most of them being over 700. So that you do recover from it more quickly. One thing that surprises almost everybody is as soon as we file the bankruptcy, within weeks, your mailbox is just full of car loan advertisements and credit card advertisements. And the reason why that you're getting those, because you will qualify. You'll qualify for car loans. You'll qualify for credit cards, which may seem just nuts. But what they're thinking is, okay, you're going to go through the bankruptcy. You're going to get your discharge. It's going to wipe out a bunch of debt. So it's going to free up some cash flow. And you can't file another Chapter 7 bankruptcy for 8 years. So in kind of a weird way, they kind of got you. So you're going to see that car loans, credit cards, high interest rates, not great loans, but they will be available early on. And then once you hit about that 2-year mark, that's when things will start going back to normal. All right, let's do one more bankruptcy question, and then we had a lawsuit question. This one said, I'm filing bankruptcy because of my car. I owe $32,000 and it's worth $15,000. Should I continue making the car payments? Because I don't want a repo in addition to a bankruptcy, assuming on the credit report. So it's a good question. There's a couple things that I want to bring up with this question. So one is, so in a Chapter 7 bankruptcy, you can surrender the car. So a secured loan like this, where there's collateral attached to it, you can actually file the bankruptcy and say, okay, I'm going to get rid of the car. It's going to go back to the bank, and then you won't owe anything on it. Normally what happens is if you file for bankruptcy or outside of bankruptcy, if you let your car get repossessed, they take the car back, they sell it, and then any balance that's still owed is called the deficiency balance. And then they're going to sue you for that balance to get a judgment, to try to garnish, that kind of thing. So in a Chapter 7, you could surrender it if the car is big time upside down like this. You can get rid of it. You're not going to owe any deficiency balance. It'll go away. I'm going to tell you kind of a little kind of cool workaround in a Chapter 7 bankruptcy that you might be able to do. But to your question, should you continue making the car payments? Depends on how quickly you're going to be filing for bankruptcy. As soon as the bankruptcy case is filed, the court puts an order in place that stops any collections against you. If it's something where you're going to file bankruptcy and you're not behind on your car payment yet, if you're going to surrender, I wouldn't keep making the payments on it. Most car lenders do not repossess until you're 60 to 90 days behind on your car payment. If you're going to be filing your bankruptcy in the next 30 days and you have a car payment that's due here in the next 30 days, I would not make that. I would just get it filed, and then you can check the box in your bankruptcy documents that you're going to surrender that vehicle as part of the process. So, you know, to your point about you don't want a repossession in addition to the bankruptcy, kind of going back to that credit thing. Okay, the bankruptcy this is the nuclear option. You file bankruptcy, whether you have a repo or late credit cards or whatever, it doesn't matter anymore. It's not going to impact things long term. The bankruptcy is going to do the damage if there's a repo, but if you surrender it through the bankruptcy, there won't be a repossession. It's just going to show that the debt was discharged in bankruptcy. Now, let me tell you about this kind of cool little thing that you can do in a Chapter 7 case. Chapter 7 cases, you can do what's called, you can redeem this car loan. And what it is in a case like this where the car is, you owe $32,000, but it's only worth $15,000. In a Chapter 7, you can buy the car for $15,000, wipe out everything above and beyond that, and keep the car. So instead of paying what you owe, you pay what the car is worth. There's a catch. The catch is you got to pay that $15,000 in a lump sum. Now, you're probably saying, John, awesome, but guess what? I'm in bankruptcy. I don't have $15,000 sitting around. But here's the catch. You can get lending. I know this sounds all backwards, but there are banks. I use a bank. I'm going to put a link here in the comments. There's specific loans that have, let's see here. They're called redemption loans. And there's this company called 722 Redemption. 722 references the bankruptcy code section that allows this. But they will loan you the $15,000 to pay off the lender so that you can get the rest of it eliminated. Now, this is all done through the bankruptcy process. This is the one loan where you actually have to be in a Chapter 7 bankruptcy in order to get it. You're not going to get a redemption loan from the guys over at 722 Redemption unless you're in a Chapter 7 bankruptcy. Not only that, the court has to approve it. So, you know, a lot of people worry, okay, yeah, great, they're going to give me a loan for the $15,000, but it's also going to be, 50% interest or something stupid. We have to file a motion with the court showing that this is going to be to your advantage. It's going to lower the payments, going to lower the interest rate, and it's going to be a better deal overall. So I don't have any financial connection with 722 Redemption. They're just the main lender in this space. But that's another option. If you're in a bankruptcy case and you have a vehicle like this, it's big time upside down. If you've rolled a bunch of other vehicles into the loan over the years, this may be a way to be able to keep the vehicle and still get rid of the excess debt. Now, it is something where, like I know 722 Redemption, they do have some limitations on it as far as the age of the vehicle. If you come in with a 20-year-old car with 300,000 miles on it, they're not going to do it. But if it's something that's still fairly new, has relatively reasonable miles on it, they can make it work that way. So, all right, let's see here. There's one other question I wanted to go over. This one has to do with a debt collection lawsuit. This person said, I sent an answer in a few months ago. Awesome. This is what we want. Again, if you're looking to do an answer, I have a tutorial solo suit. They can help you do that and actually get it filed with the court. That's the key first step to getting this dealt with. Now I received a letter stating that they haven't received my responses to discovery. Now what I do? So in this question, I abbreviated a bit. It was actually a much longer comment on YouTube. And they talked about they got a bunch of documents. So they filed their answer. And then they got a bunch of documents from the attorney for the creditor that had a bunch of statements from the original creditor and some different agreements. Those documents that they sent over, those are what we call the initial disclosures. About 30 to 40 days in most states after the answer is filed, the parties have to exchange disclosure statements. And the disclosure statements essentially is where they have to show their cards. The whole TV, Perry Mason, we always use Perry Mason. Even I never watched Perry Mason. I think that was in the 50s. But the old, gotcha thing in trial, that doesn't exist. It's something where you have to disclose everything ahead of time. You got to show your cards. So they got to show all their evidence, witnesses, all that kind of stuff. That's likely what you received in the mail. Now, some creditors' law firms will also put in there what are called written discovery requests. These fall into three categories: requests for production, interrogatories, and requests for admission. Now, I know there's one firm here in Phoenix. They send it over with their initial disclosure. And I always tell my staff, you got to look for it because the initial disclosure is this big, giant stack of documents, and they just put it at the back. And if you're not looking for it, you're going to miss it. And the reason why that's important is because there are deadlines associated with those written discovery requests. Usually it's between 30 to 40 days, and you've got to provide that. The biggest trap about this whole thing is the request for admissions. If they send you a request for admissions, and these are very simple questions, they're yes/no questions where you have to admit or deny. If you don't respond to those timely, most rules of civil procedure in most states will deem that you have admitted what they're asking you. And so the creditors' attorneys will use this as a kind of a trap, particularly against people who are self-represented and may not be aware of the rules. And they'll ask questions like, admit that you owe us the full amount that we're seeking. If they're a junk debt buyer, they may say something like, admit that we are the proper owner of this account. Or they'll say, admit that all of our documents are completely admissible into court. And then if you don't respond to it, often what they'll do is they'll follow that up with a motion for summary judgment, where they'll tell the judge, look, judge, we win. They'll attach a copy of this saying, hey, they didn't respond to it, so we need to just grant judgment. So if you get the initial disclosure, go through it all and make sure that they didn't just mail something over to you as far as written discovery. If you get written discovery, you need to respond to it timely. And that's where it's important to get into maybe having an attorney take a look at it and help you out. So hopefully that is helpful. If there are any other questions, I think we're about there. Again, I would recommend, if it's something where you're looking to talk to an attorney, I think that's a great idea, particularly for bankruptcy. I put my scheduling link in there. Feel free to reach out and set up a time to meet with me. All right, let's see here. There was one other one here. This person said, can you file for Chapter 7 for bank owed debt and payday loans? Yes, payday loans, all those kind of things can go away completely. When we look at debt, there are very specific types of debt that don't go away in a Chapter 7 bankruptcy. It falls into three real categories. Four. One is secured debt. So like I said, home loans, car loans. There's no free car. There's no free house. You have to continue to pay those. after the bankruptcy is over. Otherwise, they can foreclose on the house or they can repossess the car. When it comes to unsecured debts, things like child support, alimony, those things are called domestic support obligations in the bankruptcy world, and they do not go away. And then taxes is another one. Most taxes don't go away. However, if the taxes are at least 3 years old and you filed a return and they haven't reassessed the tax just recently, you can even get rid of a lot of tax debt. And then student loans. Student loans are still considered non-dischargeable. You know, there's a lot in the news right now about some of the debt relief that's being offered by the federal government as it comes to student loans. But even private student loans. The bankruptcy code says any loan taken out for an educational purpose, whether through the federal government or through a private loan, there's a presumption that they are non-dischargeable. So you got to be careful about that. All right. I'll just answer the question. Question. An original creditor filed suit, but has made no attempts to validate, substantiate defendant's denials in the civil answer. Doesn't the plaintiff need to prove that first? So there's kind of two different things that might be kind of intermingled here in your question. So when a creditor reaches out to you, they send you a letter, they call you on the phone, you can ask them to validate the debt. This is under the Fair Debt Collection Practices Act. The FDCPA says that if you ask them to validate it, they have to provide you with information in writing showing who the original creditor was, you know, what the debt's about, and essentially just show exactly what it is that they're trying to collect on. If they file a lawsuit against you and you file an answer, then they will provide you with the disclosures. Like I said, they're going to provide you with any evidence they have. But their time to prove their case usually comes in one of two times. One is at trial at the end of the case. That's where they have to prove their case. Or two, in the summary judgment standard or time period. Now, motion for summary judgment, we see it in almost every debt collection case, and particularly people who are representing themselves, a motion for summary judgment will be filed. And what that is, instead of going to trial, they file a written motion with the court that has all their documents attached to it. And they're basically saying, Judge, take a look at this, tell us we win. We don't need a trial. If you don't respond to that and responds to it timely and with substance, the court will likely grant it, and then it'll be over. You won't get your day in court. In the Consumer Warrior University, I have a tutorial on how to respond to that. That is one of the more complex parts of the whole process when it comes to dealing with debt collection lawsuit. And that's why I often say, hey, I would either get it out of the court process into what's called private arbitration. Again, I have some tutorials on how to do that before they file the motion for summary judgment. If they file the motion for summary judgment and then you file a motion to compel arbitration, it's likely not going to be granted. So, all right, let's see here. This one might be a little specific. Let's see. The city of Austin has a red light camera against me. Hate those red light cameras. Should I leave that off my Chapter 7 because the state has removed all collection mechanisms for traffic cameras? You're required to disclose all debts. It's actually one of the questions you're typically asked at the meeting of creditors by your trustee is, did you disclose all of your debts? So my response would be no. I would leave it on there. So even if it's uncollectible, if it's something where they're not pursuing it, I would just include it just so that there's no question that hasn't been provided or that it's been disclosed. Hey, Alex from Yuma. It's good to see you. Plaintiff hasn't provided disclosure, and then more than 40 days have passed since filing the answer. What now? So the disclosure statements, and it's always a little bit tricky because disclosure statements are not filed with the court. They're just exchanged between the parties. But in most rules of civil procedure, if you get to trial and something hasn't been disclosed, then the other side can object. So if they haven't provided a disclosure, you show up to trial, and then there they are trying to introduce all these monthly statements, bills of sale, that kind of stuff. You can object because they didn't disclose. And courts are pretty strict on that. If they didn't disclose it, they're likely it's going to be excluded. You can also, though, if there's information you feel like you need, you can reach out to the other side and ask them for their disclosure statement. And then if they don't provide it, you can file a motion to compel with the court to have it turned over. So that always falls into the category. I say, be careful what you wish for. The the less evidence that they have as the plaintiff who bears the burden of proving the case, the better it is for you. All right. Jackson says, any advice you'd give with dealing with Gerstel? Having been trying to settle with them for 50 to 60% of the balance, but they're refusing, got served with papers last Friday despite trying to work with them. So Gerstel Law Firm is big debt collection law firm. They are in the state of Arizona. They're also in the state of Minnesota, one of the more active debt collection law firms. They typically don't buy debt, but they're just the attorneys for various, particularly junk debt buyers. It doesn't surprise me maybe that they're not working with you now. The one, I always say sometimes the lawsuit is, there's actually kind of a silver lining to that. Couple of reasons. One is you'll start to deal with the attorney directly. Normally, if you're calling into a law firm like Gerstel, pre-litigation, you're dealing with just their debt collector / paralegal people who have very limited settlement authority. And so there will be opportunities in the litigation process to deal with the attorney directly, who will have more authority and ability to try to settle the account. So that may be one. Two is that you're often in the litigation process. Sometimes the case will be assigned to mediation or a settlement conference where there'll be an independent third party there to help kind of broker a deal, and you can get something more reasonable there. Or sometimes there'll be pretrial conferences where you'll be able to meet with the attorney directly and be able to kind of explain what your situation is, maybe any hardship that you're going through, that kind of thing. So I always say, obviously, the lawsuits they can be stressful, and there's more expense there, but sometimes it's easier to get a deal. Because I can tell you, as an attorney, I run into those same situations when I'm reaching out to a debt collection company and I'm just getting the runaround. Excuse me. Once the lawsuit's filed, I know the attorneys I'm going to be dealing with, and we're going to get something done a lot quicker because of that. So, it says in pretrial conferences, do I still get the attorney's fees added on, or is that only if it goes to litigation you lose? So in most states, it's like Arizona specifically where I practice, the statute that allows the other side to ask for attorney's fees is only if a final judgment is entered against you. And that usually happens if summary judgment gets entered, default judgment, or if you go to trial and lose. Pretrial conference, there's no final ruling. All a pretrial conference is, it's really where the judge is getting their arms around the case for the first time and just kind of giving you some dates, maybe setting a trial date, talking about disclosures, making sure the parties have exchanged disclosures. That's all that is. So, and something you got to be careful of and watch out for and object. If you go to trial and lose and the junk debt buyer has one of their in-house attorneys handling it, I see this a lot with Portfolio Recovery Associates and with Midland Funding. Sometimes they'll ask for attorney's fees. If they are an actual employee of the junk debt buyer, they cannot collect attorney's fees. They can only collect attorney's fees if they hire a law firm. Like if they hire the Gerstel law firm, who's just another lawyer in town to represent them, then they can try to go after attorney's fees in some cases. But if it's their own in-house people, the idea is they're not paying them anything extra. They get their salary whether they sue you or not, and so they can't seek those extra fees. So, all right, that's 30 minutes today, and I've got I have twin daughters. I don't know if I've ever shared that. My twin daughters turned 20 today, so I'm getting old, man. All my kids are getting old on me, but they're out of their teen years. So we got a family birthday party I got to get to. So I'm going to take off tonight. But hey, there's a ton of videos on there. I've got a bunch more that I've already recorded, and they're getting edited and getting sent out. Please subscribe if you haven't already. Check out our great sponsor, Solo Suit, Ascend Finance. And if you want to talk to me, my scheduling links there in the chat section. I'd be happy to set up a time to talk to you. Thanks for checking in tonight.